Thank you for listening to the Council of Institutional Investors Voice of Corporate Governance. I'm your host, Jeff Mahoney, General Counsel of CII. The purpose of these monthly episodes is to update CII members and the general public on significant developments in corporate governance and capital markets regulation and CII's related advocacy activities. This update covers the period from October 28th to December 2nd, 2025. The following is my top 10 list of events over that period. Number 10. On November 12th, Coinbase announced it had filed paperwork with the U.S. Securities and Exchange Commission for reincorporating from Delaware to Texas. Coinbase is a cryptocurrency exchange which went public through a direct listing and with dual-class stock in 2021. In a Wall Street Journal op-ed published the same day, Coinbase Chief Legal Officer Paul Greenwald lamented that while Delaware's legal framework once provided companies with consistency, it has now become rife with unpredictable outcomes. He praised the Delaware legislature for repeatedly trying to rectify the inconsistent outcomes of the once revered court through ad hoc legislative responses. However, Greenwald said companies need a more efficient and sustainable solution than relying on the legislature to fix judicial surprises after the fact. Greenwald also said Coinbase's decision to relocate is part of a larger movement of companies choosing markets with favorable regulatory and judicial review systems. He pointed to the legislation passed in Texas that places restrictions on shareholder rights, saying it empowers directors and officers to make the business decisions they need to innovate. According to the Delaware Secretary of State's office, only 28 companies have reincorporated from Delaware this year. Meanwhile, as of the end of September, 249,204 new entities were formed in Delaware this year, an increase of 14% from the same period in 2024. Number 9. On November 18th, the U.S. Court of Appeals for the Ninth Circuit granted an injunction that temporarily halts the enforcement of California Senate Bill 261, which would have required thousands of companies to publicly disclose their first climate-related financial risk reports by January 1, 2026. The legislation, along with California Senate Bill 253, is being challenged by a coalition led by the U.S. Chamber of Commerce on the grounds that the bills violate the Constitution's First Amendment, Supremacy Clause, and limitations on extraterritorial regulation. The coalition is appealing a previous decision that let the laws stand. Oral arguments on the merits of the appeal are currently scheduled for January 9, 2026. The order does not affect companies' obligations to report under Senate Bill 253, which would require business entities operating in California with annual revenues exceeding $1 billion to report their greenhouse gas emissions each year. Although no reporting deadlines have yet been established for the legislation, the California Air Resources Board announced in a November 18th public workshop that it is planning to set August 10th, 2026 as the initial reporting deadline for Scope 1 and Scope 2 greenhouse gas emissions reporting. Number 8. On November 10th, the Interfaith Center on Corporate Responsibility, United Church Funds, and Ceres filed a lawsuit in the U.S. District Court for the Western District of Texas, seeking to stop Texas Attorney General Ken Paxton from enforcing Senate Bill 2337, a law that places onerous disclosure requirements on proxy advisors. The coalition is represented by Democracy Forward. This summer, the Texas legislature passed the law which stipulates that if proxy advisors provide advice based on ESG or DEI factors, social credit or sustainability scores, or membership in an organization that bases its assessment of a company's value on non-financial factors, the advisor must provide at least 4 disclosures. 1, a statement that the service is not being provided solely in the financial interest of the company's shareholders because it is based wholly or partly on one or more non-financial factors. 2, a brief explanation of the basis of the proxy advisor's advice and recommendation. 3, a copy of the report to the company that is the subject of the service. And 4, a statement on the advisor's website that its services include advice and recommendations that are not based solely on the financial interest of shareholders. Furthermore, proxy advisors would be required to provide similar disclosures to their clients, companies, and the Texas Attorney General whenever they offer different advice to different clients that have not expressly requested services for a non-financial purpose. The bill also mandates that proxy advisors decide and disclose which of their differing recommendations was in the financial interests of shareholders. The legislation would create a private right of action for companies and shareholders to challenge advisors for failure to comply with the rule. The lawsuit argues that Senate Bill 2337 is indefensible because it violates the Constitution on at least 3 levels. 1, it restricts speech on the basis of its content and viewpoint without a compelling state interest for doing so. 2, it compels private actors to speak against their will and communicate messages reflecting the state's viewpoint. And 3, its vagueness oversteps the limits of due process because, among other things, the act would be construed to sweep in activity that is not, by any objective definition, proxy advising. Both Institutional Shareholder Services and Glass Lewis sued Attorney General Paxton in July to halt the implementation of the law, and on August 29th, U.S. District Judge Alan Albright of the Western District of Texas granted an injunction giving Institutional Shareholder Services and Glass Lewis a reprieve from compliance with the law, which was due to be implemented on September 1st. The court's ruling blocks enforcement of Senate Bill 2337 by the Texas Attorney General against only Institutional Shareholder Services and Glass Lewis and not other parties that may also be subject to the new law. The case against Institutional Shareholder Services and Glass Lewis is currently in the discovery stage, which will be followed by motions for summary judgment and a potential trial set to begin as early as February 2nd, 2026. The recent lawsuit filed by the Interfaith Center on Corporate Responsibility, United Church Funds, and Series may be consolidated with the Institutional Shareholder Services and Glass Lewis litigation. Despite the pause in implementation of Senate Bill 2023 for Institutional Shareholder Service and Glass Lewis, the law remains in effect for other providers and organizations, and its scope covers a wide range of activities related to shareholder advocacy and proxy advising. Among other things, the law exposes nonprofit organizations to liability. Number 7, on November 20th, the Florida Attorney General James Offmeyer filed a lawsuit against Institutional Shareholder Services and Glass Lewis. The lawsuit accuses the 2 proxy advisor firms of violating state law by deceiving investors and using their market power to impose an ideological agenda on corporate governance. The complaint, filed in the 14th Judicial District, which includes Bay, Calhoun, Gulf, Holmes, Jackson, and Washington counties, charges both Institutional Shareholder Services and Glass Lewis with violating Florida's consumer protection and antitrust laws, alleging they coordinated their services and steered corporate governance away from financial performance and toward controversial environmental, social, and governance, or ESG, demands. Number 6. On November 11th, the Wall Street Journal reported, multiple sources confirmed, that the Trump administration is considering at least 2 executive orders reducing shareholder rights. First, a broad ban on proxy advisors issuing voting recommendations, or a more limited ban on issuing recommendations with respect to companies that have engaged the proxy advisors for consulting work. And second, limits on how index fund managers are allowed to vote, potentially requiring them to mirror their votes in line with clients who choose to vote. And the very next day, on November 12th, the Wall Street Journal reported that the Federal Trade Commission is investigating whether proxy advisor firms Institutional Shareholder Services and Glass Lewis violated antitrust laws through their business of guiding shareholder votes on contentious topics related to environmental and social and governance shareholder proposals. Number 5. On November 14th, in comments made during an interview on Fox Business, U.S. Securities and Exchange Commission Chairman Paul S. Atkins stated that the SEC will examine and propose actions focused on the role of proxy advisor firms and large institutional investors' influence over the shareholder voting process in order to tackle, quote, the abuse of the corporate governance system and weaponization of shareholder proposals by politicized shareholder activists, unquote. Chair Atkins added that's time to focus on this particular area of corporate governance. Regarding his comments about the politicization of shareholder voting, Chair Atkins said, quote, these particular advisory companies play a role. The charges of conflicts of interest are really legion, the stories, and so we have to address this issue overall, unquote. In addition to the proxy advisor firms, Chair Atkins said that the SEC will examine large institutional investors and money managers that position themselves as passive investors but have significant influence as large shareholders over the outcomes of shareholder voting. Chair Atkins said they are passive investors. That is how they position themselves in the marketplace and with the SEC with their filings. Where they get out of line, I think, is where they act to try to influence management, and that's just not their role. While he did not specify specific planned actions, Chair Atkins said the commission will be looking at, quote, proposals and clarifications, unquote, adding that it will be within the next year. Number 4. In a November 23rd opinion piece in the Wall Street Journal titled The Proxy Process Needs an Overhaul, John Zecca, the Executive Vice President and Global Chief Legal, Risk, and Regulatory Officer of NASDAQ, stated that NASDAQ has long advocated for reforming the proxy process and that they are encouraged by reports that the Trump administration is considering an executive order to address the issue. Zecca alleges that proxy advisor firms wield disproportionate influence over the trajectory of corporations while operating with minimal accountability. Zecca also states that they welcome the proposal by Representative Brian Stile of Wisconsin in the Protecting Americans' Retirement Savings from Politics Act, which would require proxy advisor firms to register with the U.S. Securities and Exchange Commission and to disclose publicly any conflicts of interest. The proposal also would require proxy advisors to provide companies with a reasonable opportunity to respond to any errors in their voting recommendations. In addition, Zecca asks that regulators should push to let companies communicate directly with their shareholders through technology-driven solutions. He adds that the blockchain, for instance, could offer a secure channel for communication. Finally, with respect to shareholder proposals, Zecca stated that NASDAQ encourages the SEC to revisit the minimum voting thresholds required for a shareholder proposal to be resubmitted in subsequent years to prevent repeat unsuccessful proposals from jamming the process. Number 3. On November 5th, a coalition of investors sent a letter asking U.S. Securities and Exchange Commission Chair Paul S. Atkins to meet with them to discuss the changes to the application of Rule 14a-8 he suggested in an October 9th speech at the John L. Weinberg Center for Corporate Governance. In that speech, Chair Atkins referenced a law review article by Delaware attorney Kyle Pinder of the Delaware law firm Morris, Nichols, Arsh, and Tunnell. Pinder's law review article suggested precatory shareholder proposals may not be proper under Delaware state law. The SEC chair also indicated that the commission staff will now concur with company no-action requests that assert such shareholder proposals may be excluded from the company proxy materials if it is not a proper subject for action by shareholders. The letter, which was signed by representatives of the AFL-CIO, Series, the Interfaith Center on Corporate Responsibility, the Shareholder Rights Group, and UFSIF, said, quote, in effect, your argument upends more than 80 years of practice by endorsing a novel legal theory that would eliminate a core ability of investors to engage with their portfolio companies and each other at company annual meetings, unquote. The correspondence also references a November 4th Council of Institutional Investors webinar during which Kyle Pinder clarified that if the Feds say precatory proposals are one means that they would like for stockholders to be able to communicate pursuant to the proxy rules, Delaware is okay with that. We're not saying Delaware law prohibits or that a precatory proposal would violate Delaware law. It's that they're not a state law thing. It's really they're by virtue of the federal proxy rules. The coalition points out that in his Delaware speech, Chair Atkins said if a Delaware lawyer states in a no-action letter that a shareholder proposal is not a proper subject for shareholder action, the SEC staff are likely to honor this position. The letter argues that if this is how the SEC will rule on no-action requests in the future, it will lead to at least 4 negative effects. 1, will undermine the practice of the commission staff performing neutral, unbiased legal analysis. 2, it'll interfere with them exercising the independent judgment necessary for their role. 3, it will disadvantage shareholders. And 4, it will erode public confidence in the objectivity of the SEC's no-action process. Letter advises Chair Atkins to subject any changes to Rule 14a-8 to a formal rulemaking process and warns that his suggested changes could encourage shareholders to file binding proposals instead of precatory ones. The coalition asks, do corporate issuers really want to encourage their shareholders to instead submit more binding shareholder proposals that would amend company bylaws? Letter explains that precatory proposals have facilitated private ordering by companies on a large variety of widely followed corporate governance best practices. Coalition argues that the elimination of these types of proposals are likely to spur the introduction of more binding proposals, which will result in needless litigation and reduced board discretion. Number 2, on November 17th, the U.S. Securities and Exchange Commission made an announcement indicating that Commission staff would refrain from weighing in on most no-action decisions this proxy season, and many commentators were quick to express their strong objections to the move. The statement issued by the SEC said a backlog of registration statements and other filings had accumulated as a result of the government shutdown. It said staff members must focus their attention on those matters instead of devoting attention to deciding if shareholder proposals should be included in corporate proxy statements. The only exception the Commission provided was for shareholder proposals being challenged under Rule 14a-8I1. which allows companies to exclude proposals that are not proper matters for shareholder votes under state laws. The announcement applies to the current proxy season, which the SEC defines as the period from October 1st, 2025 to September 30th, 2026. The announcement also applies to no action requests received before October 1st, 2025, to which the SEC staff has not yet responded. Companies looking to exclude a proposal for any basis still will be required to notify the proponents of the proposal and the SEC of their intention at least 80 days before filing a statement. If a company includes in its notice an argument that it has a reasonable basis to exclude a proposal based on other provisions in Rule 14a-8 or prior published SEC and or judicial decisions, the SEC's Corporation Finance Division will respond with a letter. That letter will indicate that based solely on the company's or its counsel's argument, the division will not object if the company omits the proposal from its proxy materials. The division staff will not evaluate the adequacy of the argument. A Washington, D.C. attorney with expertise in shareholder proposals explains that by specifying that the SEC staff will only decide on exclusions based on Rule 14a-8I1, the SEC is looking for an appropriate test case to get the Delaware Supreme Court to weigh in on precatory shareholder proposals. He added that his interpretation is supported by language in the SEC's announcement that states, regarding the application of state law in Rule 14a-8I1 to precatory proposals, the division has determined that there is not a sufficient body of applicable guidance for companies and proponents to rely on. The division will continue to express its views until such time as it determines there is sufficient guidance. Reactions to the SEC announcement came swiftly and many were strongly worded. Representative Maxine Waters of California, ranking member of the U.S. House of Representatives Financial Services Committee, said, "I am calling on Chairman Atkins to withdraw this decision immediately and to do the job he was assigned." Ranking Member Waters added, "The agency that calls itself the investor's advocate should not be in the business of rubber stamping corporate executives' attempts to silence investors or arbitrarily rewriting decades of precedent." In a written statement, SEC Commissioner Carolyn A. Crenshaw labeled the action a giveaway to issuers and an act of hostility toward shareholders. Commissioner Crenshaw also criticized the announcement for giving the false impression that the division is not objecting to a company's position because it agrees with the grounds of the submission, when in fact it is not objecting because staff has been ordered to rubber stamp those submissions irrespective of their content. Commissioner Crenshaw warned this is the latest in a parade of actions by this commission that will ring the death knell for corporate governance and shareholder democracy, deny voice to the equity owners of corporations, and elevate management to untouchable status. Eric Girding, a partner at law firm Freshfields, who previously served as the director of the SEC's Division of Corporation Finance, wrote that without further changes, the announcement from the staff today will alter the shareholder proposal process and shareholder engagement dramatically over the course of this proxy season and potentially permanently. Girding also predicted that state courts will soon be the battleground of this shift, as Delaware and other states will need to establish whether precatory proposals are proper matters for a vote. If they are, states will need to establish whether all types of matters are appropriate for precatory votes. Daniel Fugere, president and chief counsel at As You Sow, stated that by stepping back from the no action process, the SEC is effectively forcing these matters into court, an expensive and lengthy outcome that is detrimental to both shareholders and companies. Sanford Lewis, director and general counsel of the Shareholder Rights Group, cautioned that issuers and governance organizations should not be misled into thinking that a no objection letter provides certainty about potential enforcement actions from proponents and potentially even from the SEC when the agency finally has cause to assess the merits of the exclusion claims. Cynthia Cruz, a partner and co-chair of the global board at law firm Evershed Sutherland, told Pensions and Investments that she thinks companies' fear of eventual enforcement actions might lead to more shareholder proposals appearing on proxy ballots this proxy season. Cruz asked, if you excluded something, what would happen to your reputation, your stakeholders? She added, so I think it's going to weigh on management. You could have an opposite effect, which is you have a lot more shareholder proposals and proxies because nobody wants to have the exposure out there. And my number one most significant development in U.S. corporate governance and capital markets regulation for the period from October 28th to December 2nd, 2025, occurred on November 6th, when the Council of Institutional Investors sent a letter to SEC Chair Paul S. Atkins expressing serious concerns about a Commission September 17th policy statement. That policy statement explains that the SEC would no longer factor the presence of mandatory arbitration clauses in corporate governing documents when considering whether to accelerate companies' registrations for initial public offerings. Previously, the SEC refused to accelerate registration statements with these clauses, which deterred companies from including them in their governing documents. Mandatory arbitration may force shareholders to pursue claims against companies for violations of federal securities laws in a private, confidential form instead of in a court and without the option of filing class action lawsuits. The CII letter points out that the policy statement reverses, without the benefit of public comment, the SEC's long-held view that shareholder arbitration clauses in the governing documents of U.S. public companies is contrary to good public policy. CII's letter also explains that the SEC's policy statement contradicts CII's membership-approved policy, Section 1.4, Accountability to shareholders, that was approved by CII members in 2012. That membership-approved policy states in part that companies should not attempt to bar share owners from the courts through the introduction of forced arbitration clauses. The letter also emphasized that CII is not opposed to voluntary arbitration. A group of 61 state and local pension funds, union pension funds, university pension funds, and shareholder groups also sent Chair Atkins a letter on this topic on November 3rd, expressing their strong opposition to the SEC's policy statement. Their letter warns that under the new policy, companies that violate federal securities laws will be shielded from public accountability, putting investments at risk and stripping investors of their well-established rights to recover losses on a class-wide basis and in a proceeding that provides them with full due process. That completes my monthly update on significant developments in corporate governance, capital markets regulation. If you have any questions regarding any of the issues discussed, please feel free to email me at Jeff, that's Jeff, at CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to the Voice of Corporate Governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.